All right, this one's on risk, not negotiation and disputes. That's coming up in the next set of lectures, so we'll take that out of there too. Why not? All right. So risk allocation and contracts. This is going to be who's responsible for anything that happens that's unforeseen. Things that happen, like you can't get sheetrock. That's not truly an unforeseen risk. It's things that are just logistics. It gets into a little bit of gray line when it gets to the logistics of supplies and that sort of stuff. But ideally, you can figure out where to get some sheetrock or something. But there are things that happen that just causes a delay in your schedule, and you want to know who's going to be responsible for them, basically. So the first one that's always a big one is number one here. Um, so force majeure, it's basically called an acts of God, or it comes down to it's a natural disaster such as flooding or a meteor strike. You could have something that was really that interesting. Forest fires, that kind of stuff. When a dam breaks and causes unforeseen flooding of the valley, and whatever construction was going on down there is wiped out. Basically, it absolves the contractor or the owner from payments due to loss of income. So basically, that's the insurance company's um, way out of things if you're insured. But from a contractor standpoint, you want to not be held accountable for um, force majeure, so you try to write that into your contracts. And that manages the risks from unforeseen accidents. All right, indemnification. All right, absolves the parties from any accidents caused by an outside party. So you could have a um, car crash into the construction site. You could have the neighbor's property next door catch on fire and it burns across the property lines and burns the construction project that you're on. Um, that would be unforeseen and be something that you really don't want to be paying for. Liens are the ways to spell out who's obligated for the contractor's debt. Um, so if a contractor goes bankrupt and hasn't paid their suppliers, the suppliers can go back to the owner by placing a lien on their property. Well, if the lien is if the contract is defined so that the contractor is the one that the lien's held against, then the owner has free will of their property. But if there's a lien on your property, the courts will see that as you need to pay the subcontractor for the losses that the um, contractor didn't pay or the supplier that the contractor didn't pay. So therefore, the owner is always trying to figure out how not to be the one that the lien goes against. So a lien is a legal action by the court to um, freeze any assets at that time and make sure that somebody's responsible. So, all right, labor laws. It's important that you pay fair wages and adhere to the Department of Labor regulations. Defines who's going to do that. Differing site conditions. This one's interesting from the standpoint that you may start out with a property that as you dig the foundation, you find out there's a underground stream that flows through the foundation, and that was not anything that came out on the data from all the core samples to tell you that was there. Now, how are you going to fix it? So that gives you a way to still get more money from the owner because you discovered something that was not known until you did the digging. So the example I gave here was you dig up a toxic waste dump, and then you're in trouble. But more likely, you're going to find something where there's an underground stream that's been flowing through that area and no one ever knew it. And your foundation will be flooded. Um, okay, who's responsible for delays and extensions of time? That'll be written into your contract. Liquidated damages, who pays for the defects, and it's all agreed upon in advance. So let's say you on your construction site, you drive the payloader into the main part of the building when you're putting an addition on. Who's responsible for repairing that? Well, it's probably going to be the contractor, but it has to be stated in the contract that that's who's going to pay for it. All right, consequential damage, that goes along with number 7. In the example I gave you here is a crane operator swinging an air handler through the side of the building. Who's paying for that? Might be the subcontractor, not the actual contractor. So somebody's always looking to blame somebody else is really what it comes down to. Occupational safety of health of the workers, basically see OSHA regulations. If you're over a certain number of employees, you have OSHA rules to follow, but OSHA is probably a good idea anyway. So safety glasses, hard hats, boots, safety vests, gloves, that sort of stuff probably should all be part of your personal protection, but things that go along with trip accidents and how to not have cords laying across floors and that sort of stuff are always part of OSHA's interest. All right, the contract will also lay out who's required to get the permits, the licenses, the laws, and the regulations, and who's responsible for all those ahead of time. All right, next thing that'll probably go in a contract is, are you following equal employment opportunity regulations? Mostly everybody does. That's part of the not New York State, but federal law now. All right, terms in here of how to terminate the contractor and what would cause the termination by the owner. Those will be laid out. Who can suspend work and what happens during suspension of work? Because bills have to be paid. People need to be laid off. All kinds of things happen with that. So you want to know something about if something goes horribly wrong. Say the code enforcement officer decides to stop construction because something isn't meeting code. You all just can't stand around twiddling your thumbs. Someone's going to want to get paid for something. All right, and the last one is warranties and guarantees of the building. Who's going to be responsible? It's usually called a punch list. At the end of the job, a contractor is working on a punch list to determine the last bit of things to make the owner happy and bring it up to the quality that everybody's expecting. So, all right. All of that stuff above winds up in some, good language that you usually need a decent lawyer for, and they will comply with the jurisdiction for what they're working. So everybody's always interested in where the work's going to be done and who's responsible by which laws and that sort of stuff. So, all right. The good news is there are places to get contracts. So if you're starting your own business or running one from somebody else's business, you have a place to go get this. The American Institute of Architects and the Associated General Contractors have contracts that are standardized, that have passed the review of many court cases, and basically are usable, and you just have to buy rights into using it. So the only thing I will add to it is there is never a 100% guarantee that there is not going to be a problem. Guess I should finish this sentence though. All right. So I gave you, whoa, let's not go that fast ahead. I gave you a couple examples here. We'll go to the first one. You can come into OneNote and see the rest of them here. But provisions of a high risk, high contract risk. Okay. And this is from the Carnegie Mellon University book that I've given you guys a PDF for. So chapter 8 of that book. Except where the sole negligence of the company is involved or alleged, contractor shall indemnify and hold harmless the company, that be the owner, its officers, agents, and employees from and against any and all losses, damage, liabilities, and from all claims for damages on account of or by reasons of bodily injury, including death, not limited to employees of contractor's company, contractor and the company, the owner, and any subcontractors of the contractor, and from any and against any and all damages to property, including property of the company, third party, direct or consequential, caused by or arised out of, in while in or in part, or claimed to have been caused by, or to have arisen out of, in whole or in part, an act of omission of the contractor or its agents, employees, vendors, or subcontractors, of the employees or agents in connection with the performance of the contract document, whether or not insured against, and contractor shall, at its own cost and expense, defend any claims, suits, actions, or proceedings, whether groundless or not, which may commence against the company, the owner, by reason thereof or in connection therewith, and contractor shall pay any and all judgments which may be recovered in such actions, claims, proceeding, or lawsuit, defray any and all expenses, including cost and attorney's fees, which may be incurred by reasons of such actions, claims, proceedings, or lawsuits, and period. That whole paragraph is one sentence. And that is the reason that's written that way is that the lawyers can't pick it apart. It's everything in that sentence is what is the meaning behind that whole section. If you take a period and put it in there any place where it felt like there should have been a period, then you are separating that out and it causes things to be taken apart, which has gotten people in trouble. So lawyers write it in this way to make it wordy and cover everybody. So, all right. So the one thing that who's our author? Tim something wrote is gave you this this is a very burdensome provision for the contractor. It makes the contractor responsible for practically every conceivable occurrence and type of damages when the claim or loss is due to the sole negligence of the owner. All right, so that's a tough one to live to, but that's when there's really some high risk. So you want to be careful. And he gives you a couple other examples here where it's not so, well, it's still wordy, but takes the responsibilities off the contract altogether. So let's take a look at number 3 because that's a really small one. The contractor, you hereby agree to indemnify and hold the owner or any parent, subsidiary, or affiliate of the company and its officers harmless. Okay, same thing we saw up above. And you can see how this one kind of gets into the less demanding of the contracts. So it's a lower risk. Cool. All right, so that's the risk clauses that go into contracts. And I'll have another video for you on Wednesday. And, well, actually, another couple of videos for you on Wednesday. But you guys have a good day today. Thank you for watching.